All right. And I think just like that, we are recording. I want to begin by saying thank you, Sarah. I've invited Sarah Gubler of Gubler Wind Trusts and Estates on the call today. And Sarah's going to, we just kind of want to do a little 101 on what is an estate, or what is a trust, excuse me, and kind of run through the differences between trusts and wills and basically your whole world. So I guess the first place to start is, what is a trust?
Great question, Steve. It's not the easiest thing to wrap your head around. So when I explain a trust, I like to use the example of a box. A trust is like a box that during your lifetime, you put assets in, you take assets out. So the box has an open lid. This is a revocable trust I'm talking about. First of all, I should mention there are different kinds of trusts, and maybe we'll get into that later, but a revocable living trust is similar to a box in that you're putting things in, you're taking things out, and then what happens when you die, it's like a lid goes on the box, and someone else can step into your shoes as the trustee or the kind of manager of what's in that box and make happen what you want to happen. So they can make, take care of your house, distribute your assets to kids, do whatever you've set up the trust to do. And the difference is without a trust, you just have assets. You have a house, you have a bank accounts, brokerage accounts, and when you pass away, those things are still owned by you, and that's where there's a problem. That's when a bank doesn't know what to do with this bank account where the bank holders passed away. Like the county who has a title on record in the name of someone who's passed away can't do anything, and that's when a court has to step in and direct these institutions on how and who to pass these assets to. So a trust eliminates the need for any court, and instead contains your assets in a way that allows them to pass with any kind of without any kind of court intervention.
So the wonderful thing for all the millions of viewers that we will have on this recording, I get to ask all of the stupid questions on their behalf.
Let's hear them.
So most people have heard of a will. It sounds like what you're saying is that a will is different than a trust, and a will might be in that box of a trust. Is that fair?
Well, so a will kind of goes with a trust, frankly. When I draft a trust, I always draft a will as well. The wills that I draft alongside a trust are called pour-over wills, and what they act as sort of a catch-all. So if there are certain things that you didn't properly title in the name of the trust that aren't in the box, the will pour those things over into the trust and allow them to be distributed under the terms of the trust. Now, when people have only a will and no trust, they sometimes have this sort of false sense of security that, they've thought through who they want to take what, their family will be fine, it's going to go smoothly, there's no need for a court. A will, and that's true, a will is helpful in that it lists people's, plans and desires at a point.
It's better than nothing, is what you're saying.
Absolutely, but I think what people understand is that it in no way avoids probate. So wills have to be what's called lodged with a court, and it's a judge who will look at the will and grant the executor official power to act on behalf of the estate, and then we'll kind of oversee the whole process. So a will is a helpful guide for sure, but it doesn't avoid probate in the same way that a trust avoids probate.
Interesting. So if I have some assets, let's say I have a house and a couple of cars and a 401k, and I have a will in place, you're saying that potentially I could still run into probate. Of course, is a court system where the court has to figure out, basically my understanding is figure out how the will gets administered. Even if I say, I have a house, I have two cars, and I have $100,000 in a 401k, and when I die in this will, it says it's all going to go to my kid or spouse or to the neighbor or whoever I want to present it to, that potentially just a will doesn't avoid the court system. Is that accurate?
Correct. Yeah, and the reason for that is, if I'm the executor of my brother's will and it says, all of his stuff goes to his kids, I can't go to San Diego County Recorder's office and say, look at this will. It says that this house is supposed to be transferred to these kids. go ahead and make the transfer. They'll say, well, who are you? Is this valid? They'll need an order from a court that says, yes, we've looked at this will, this person is the executor, the house has been, appraised, blah, blah, blah. We've gone through all the steps, and then the county will transfer the house. So, and that's all part of the probate process, which is just a long, kind of arduous process that can take 1 to 2 years. You lose, 5% usually of an estate's value in probate fees, and it's just a pain. And the bottom line is it's very avoidable, not only by a trust. There are other ways to avoid probate, but a will alone will not avoid probate.
So a couple other questions. Who needs a trust? You're talking about assets. You're talking about people that have, as we mentioned, a house, cars, hundreds of thousands of dollars, let's say, in retirement accounts, etc. What if I don't own a house? What if I'm renting? What if I'm single? What if I don't have a family? Do I still need a trust?
Mm-hmm. Yeah, no, that's a good question. No, I don't believe, and other estate planning attorneys might tell you differently because they want to write trusts, but I don't think everyone needs a trust, to be quite honest. That said, the world of people who do is much larger than I think people realize. So single people who don't have families, but maybe you bought a condo and you own real property in California, albeit something modest. That modest piece of property in California is likely well over or worth more than $150,000. And I throw out that number because if your estate is worth less than 100, it's actually just been increased to about $160,000. You can go through probate in a very simplified, quick manner. So if your estate is worth less than that, I would say you don't need a trust, and a will would be fine to direct what you have to who you want, because it's a simplified probate process.
And I'm going to interrupt and ask a definition. When you say an estate, you mean basically everything put together. My house, condo, cars, money, is that encompassing into an estate, or what makes an estate?
Yeah, so that is your estate. Everything that you own. Oops, let me just pause that. Everything you own is part of your estate. But there are some different kind of subcategories of estate. There's something called your probate estate, which is everything that would have to go through the probate process. So if, for example, you have a trust and you've put your house in the trust, and then later you acquire another property and you forget to retitle it in a trust, technically that second property becomes part of your probate estate. But there are ways to hopefully, after you pass away, get that funneled into the trust. But anyway, anything you die with that has to be probated would be a probate estate. So back to our example of the single person with a condo, if that person doesn't have a will or a trust, the condo, his any bank accounts, any retirement accounts that he might have, pensions from work, whatever, all of that make up in his case, both his estate and his probate estate, because he has no trust. So when all that together adds up to more than $160,000, a formal probate will have to be opened, which means
More
an
money.
attorney and more money.
Okay.
So I recommend to my clients that if you own real property at all, a trust is really important. I also think if you have kids, a trust is really important, simply because it's not always the best idea for kids to just inherit things outright. I mean, you likely want to have a little more direction about when and how they receive whatever they receive, even if it's a modest inheritance. And a trust is the way to really tailor that to how you want things to go.
I love it. So I want to respect your time. 2 more quick questions. Number one is, we talked about types of trusts. And as a realtor, I've heard about revocable trusts. I've also heard about living trusts, non-revocable. What are the differences? Why would somebody want one over another?
Okay, good question. Yeah. So revocable trusts and living trusts are basically synonymous. And that all that refers to is the box with the open lid that basically, you're taking things in or putting things in, taking them out of throughout your life. So a revocable trust / living trust has, three key players to it. There's the creator of it, the beneficiary of it, and the trustee of it. And during your lifetime, you're all three of those things. That's what makes a revocable trust revocable. You can revoke it at any time, you can amend it at any time. It's like this living kind of breathing thing. An irrevocable trust, and there are lots of different kinds of irrevocable trusts, is created by the creator or the grantor. Their assets are put into it usually for the benefit of someone else. Someone else is a beneficiary, and always they're managed by a third party, which is a third party trustee. And these are irrevocable by the creator, which means they can't amend them, they can't change them. And a lot of times they're done, we do these to protect assets from creditors or that kind of thing, or to, if there's going to be a tax issue down the road with federal estate taxes, you can sort of put things into a separate irrevocable trust. So these are kind of they're more advanced estate planning techniques that use irrevocable trusts. The most common irrevocable trusts are usually, they're called ILITs. They hold life insurance policies, and actually they're a great tool to get a life insurance policy that won't end up being taxed upon your death because of the federal estate tax. Federal estate tax, by the way, right now, there's an exemption up to $11.2 million, or actually it's like 11.4 now. So most people don't really have a federal estate tax problem when it comes down to it. But there are tools, for those who are cursed with worrying about taxes because their estates are just that large that they need to worry about.
So likely the demographic, my last question here, likely the demographic that would need a trust, someone our age, starting out, getting a home, having a family, this person, and you use a different word, I pronounce it revocable, but you call it a revocable. Most people, probably the vast majority, would have a revocable trust or a living trust that is this open box that put things in and take things out. Is that accurate?
Exactly. Yep, that's exactly right. An irrevocable trust only becomes irrevocable upon the death of the grantors. So you'd create it, it would be living throughout your life, revocable throughout your life. And then when you die, it becomes irrevocable, and that's when a trustee steps in to manage it for you.
And so any changes to that trust, whether someone went through a divorce, or if I have a trust that was written in 2005 and then I've had children and now all of a sudden it's not saying that they're in the trust, because it's that open box, if someone is going through a divorce, they can either make changes to that by essentially taking the items out or doing amendments or addenda, I would imagine, in some way of putting in, hey, by the way, we've had a kid and now they are going to be a trustee or something to that effect. Is that?
Exactly. Yep. You can amend a trust with a simple amendment, or sometimes people go ahead and do what's called a full restatement of trust, which feels like a new trust, like when people have kids. Sometimes the whole trust is structured without kids in mind, and it might be good to just restate the whole thing. But the bottom line is the revocable trust from the gates remains just that: revocable, amendable, changeable. And it's because there's just no telling what life will bring, and it's a great tool to be able to change and really tailor to your life as you go along.
Sarah, this is so wonderful. I really appreciate your time in doing this. If I am a consumer that's watching this and wants to connect with you, what's the best way to connect with you?
So you can go to my website. My firm, once again, is Gubler Wynn Trusts and Estates. My website is www.gublerwynn, gublerwynn.com.
How do we spell that?
Gublerwinn, Gublerwynn. My email address is sarah@gublerwynn.com. My phone number is on the website as well. And I've loved talking to people and answering questions, especially during these crazy times we're in. And so I encourage you to give me a call if you have any additional questions.
Is there a fee for that, for you to have a conversation at the beginning?
No, initial consultations are absolutely free. And then even when I do quote a fee, it's usually, I try to give a flat fee to clients so they know what to expect out of the gates. And initial consultations are always free. So give me a call.
You're the best. I really appreciate you taking the time to do this. It really is so helpful, and absolutely, if we have any questions, we will reach out to you. I wish you a great day, and we will be in touch here very soon.
Thanks, Steve. This was a pleasure. I'll see ya.